On February 28th, 2023, just days before the Murdaugh trial ended, Becky is accused of either releasing or making sealed evidence, photographs, available to a third party in violation of Judge Newman's court order. Those photos are believed to have been of Maggie Murdaugh's and Paul Murdaugh's bodies at Moselle. On January 29, 2024, Becky is accused of lying about this on the stand when Justice Jane Doe asked her whether she had done this. Sometime during or after Alec's trial, photos of Paul's and possibly Maggie's dead bodies began circulating in some sort of text chains or in social media messages. The origin of that photo or photos is believed to have been a member of a South Carolina news agency. As for the misconduct charges, Becky is accused of misusing her office on June 7th, 2023, when she was allegedly promoting her book about the Murdaugh trial during work hours. She is also accused of misusing federal Title IV-D incentive funds to pay out bonuses to herself and others between September 1st, 2021 and March 5th, 2024, which is a few weeks before Becky resigned from the clerk's office. Now, how much jail time is Becky facing? It's hard to say. The perjury charge carries a sentence of up to 5 years, but the other 3 charges have sentencing guidelines that leave it up to the judge. We've already been asked several times about whether we think these charges will affect Alec's appeal and his quest for a new trial. As for the appeal, no. That comes down to an interpretation of law and whether Justice Doe was correct in not allowing there to be a full-scale evidentiary hearing to determine whether Becky had tampered with Alec's jury, which we still maintain she did not. As for a new trial, if Alec wins his state appeal or loses his state appeal and then wins his expected appeal in federal court, then there's no doubt that Dick and Jim, or whoever is representing Alec Murdaugh at the time, will use these charges to paint Becky as a liar. At this point, the only assessment we can give you right now is expect chaos and expect to see the old circus come back to town.
That said, let's all pause for a moment and ask ourselves this question. Why is Becky Hill the only public official who has been charged in the Murdaugh mess? What about Solicitor Duffy Stone, who was reportedly running a shadow investigation, steering detectives away from looking at Alec Murdaugh? And what about Greg Alexander, the Yemassee police chief, whose role in escorting John Marvin Murdaugh to the scene on the night of the murders still does not make sense to us? What about Carmen Mullen, the judge who cleared the way for Alec Murdaugh to steal millions of dollars from the Satterfield family despite all of the red flags that she somehow missed? What about all the lawyers who knew about Alec's multi-million-dollar thievery and did nothing for all of those years to stop it? I'm glad that Becky Hill was charged, but I am disgusted by members of the media pretending like she is the only bad apple in Murdaugh's world. Becky is only different from the rest of the bad apples because her arrest helps Alec Murdaugh's narrative. We have 2 big updates in the Colucci and Micah Francis cases to share. We confirmed this week with the South Carolina Attorney General's office that the Colucci trial is now slated for June 16, 2025 in Berkeley County, South Carolina, and it's scheduled to last 2 weeks. We hope that the Attorney General's office brings its A-game here because Michael Colucci's defense team appears to be going hard this time around. They filed 31 motions in April, and we'll talk about those as we get closer to trial.
On April 29th, J.P. Miller filed another absurd counterclaim against Jane Doe No. 2. Honestly, it's an insult to the legal profession. Russell B. Wrong, appears to have copy and pasted his Jane Doe No. 1 countersuit almost word for word. In his legal answers to both lawsuits, J.P. and Russell appear to have copy and pasted the same vague sentence more than 500 times that says, defendant lacks information sufficient to form a belief as to the allegations contained in paragraph whatever, and therefore denies the same and demands strict proof thereof. I'm not kidding. If I didn't know any better, it would almost seem like they were taunting Jane Doe No. 2 for her allegation that Wayne Miller made her write that she wouldn't lie about JP 5,000 times. In JP's counterclaim to Jane Doe No. 2, JP and Russell say that JP has been put in harm's way by Jane Doe No. 2's public accusations. and they have caused a barrage of libelous and slanderous conduct by many others and relentless cyberbullying. On May 12th, Jane Doe No. 2 filed her response to JP's counterclaim, which was similar to Jane Doe No. 1's response, which was basically, girl, no. And this is interesting because you would have thought that JP would have learned from Jane Doe No. 1's responses, and you'll see why. Because in her response, Jane Doe No. 2 argued that the court should dismiss JP's counterclaims for failure to state specifics, meaning he has to provide the specific statements that he is claiming were defamatory, libelous, or slanderous, give the context, and say who the third parties were that those alleged statements were made to. All of that was in Jane Doe No. 1's response, and yet he made that counterclaim against Jane Doe No. 2 nonetheless. Jane Doe No. 2's response said, the counterclaim fails to identify the specific social media posts or appearances that allegedly caused harm to defendant JP Miller, nor does he provide any evidence of actual malice from Jane Doe No. 2. I especially loved how Randy Hood and Mark Tinsley politely explained to JP and Russell in their latest filing, again, how defamation works. Quote, to state a claim for defamation, libel, or slander, the defendant must allege with specificity the false statements made, the medium of publication, and how these statements have caused him harm. The counterclaim lacks these. In other words, they didn't do it right. In the eyes of the law, specifics matter. Details matter. Evidence matters. JP is learning over and over again that he can't just cry defamation and slander 500 times in 500 different ways and expect people to be scared into silence. This mess is too big and the sunlight is too bright. The allegations are too heavy, and no one is quitting this fight before we see justice in these cases. In her response, Jane Doe No. 2 is asking for the counterclaim against her to be dismissed and for the court to award her attorney's fees. She's also asking that JP be sanctioned for abuse of process. We cannot wait to see what happens next there because JP is so in over his head.